everybody. Yes, the name of the firm is Pavia and Saldo. We are from Milan and full service law firm. The presentation will be about, I cut it short, about secret prior art in the USA, and will be presented by Justin Krieger, who is a partner at Kilpatrick Townsend and Stockton LLP in US. I had the chance to read it. It's kind of technical, but very interesting for practitioners in the patent field. And the second presentation will be held by Justin Krieger, no, by Bastian July, sorry, who used to be a practitioner as well, but now is the CEO of a firm of consultancy in the IP field. He told me that he's on the good side of consultancy to make, he told me, I'm not in enforcement. I said, okay. So he's going to tell us how he's dealing with this matter. And, well, for the time being, that's it. So go ahead.
Thank you for that fine introduction. It's great to be here today. I want to thank IIPLA for having me. Today I'm going to be speaking about secret prior art. And it sounds like an oxymoron a bit, doesn't it? Secret prior art. And in a way it is. It's also an issue of great importance, and that has seen a significant deal of change over the last few months and years, in particular with the enactment of the America Invents Act in 2011, and for purposes of this discussion, that went into effect for applications filed on or after March 16th, 2013. But in addition, there's a case right now, Helsing versus Teva, which we'll talk about a little bit, that's currently on appeal to the Supreme Court, that hopefully will address this issue in greater detail so we can have a little bit more clarity of exactly where we stand. But it is an extremely important issue, in particular for small and medium-sized pharmaceutical companies who may not have the resources to manufacture and distribute their drug compound on their own, and they have no choice but to work with a third-party manufacturer in order to distribute their drug compound. And they need to be aware that those sorts of discussions can create an invalidating act, even if they're undertaken with a non-disclosure agreement in place. And that's something that comes to a surprise to many European practitioners, because they typically operate under the understanding that if they're operating under a non-disclosure agreement, they're generally free and clear for patentability, and not necessarily so, at least with respect to US patents. So it's important that these small and mid-sized pharmaceutical companies understand the risks associated with these discussions and take appropriate measures to make sure that their IP is fully protected. Okay. So prior art, we all have different notions about what prior art is, and generally speaking around the world, it typically includes information that's in the public domain and that's available to the public. And that makes sense because you don't want to give somebody a patent for something that's already in the public domain, right? It also varies from country to country, and so there are different nuances from country to country, but generally speaking, that seems to be the overall consensus, that information that's publicly available or in the public domain is what constitutes prior art. And the easy calls are like patents, printed publications, journals, books, that sort of thing. Now the US law is not so limited to that, and actually goes broader and includes certain categories of secret prior art, in particular when it comes to offers for sale. So here's the situation we're going to be talking about today. So you can see a timeline on the top, and assume that an inventor in 2000 makes an offer for sale of a product made by a trade secret process. The process remains secret, and you can also assume that there's a non-disclosure agreement in place as well. And then they file a patent application in 2012 or 2014. Those dates are important because 2012 was the pre-AIA law, and in 2014 would be after the AIA. So post-AIA law would apply. And so basically in the US, we're currently operating under two completely different systems of law, which is great fun, as you can imagine. So then the patent grants, and assume that throughout the entire process up until the patent application was filed, it remains secret. The question is that patent valid or not? And like so many legal issues, it depends. And it's also not exactly clear at this point. But we can start by looking at the old US law. This is old Section 102 pre-AIA. And it says that a person shall be entitled to a patent unless the invention was patented or described in a printed publication in this or a foreign country, or in public use or on sale in this country more than 1 year before the date the application was filed. So, according to pre-AIA law, an applicant must file a patent application within 1 year of their first offer for sale in the U.S. This includes secret offers for sale. So any offer for sale at all triggers the bar for that individual, for the inventor, him or herself. Now, it's noteworthy that this is limited to offers for sale in the U.S., so if you made an offer for sale in Germany or the U.K., you would not be subject to this bar, at least under the old law. Now, courts have interpreted the on-sale bar as being a personal bar to patentability. So it's prior art against that individual who makes the offer, but not against somebody else who might independently develop the invention. So it's a little different type of prior art than like a printed publication, which is prior art against everybody. So since it's a personal bar, it's commonly referred to in U.S. cases as the forfeiture doctrine. And the rationale behind the forfeiture doctrine is that it's against the public's interest to effectively extend an inventor's monopoly by having them keep it as a trade secret for like 10 years and then decide to file a patent application. Now, I personally don't really agree with that logic. I don't think they're getting the benefit of the patent bargain. They certainly, while they're keeping it a trade secret, cannot exclude others from making and using the invention to the extent that they independently develop it. Also, they're taking a serious risk that somebody else might independently develop it and get a patent on their own. So I don't really buy into this rationale, but nevertheless, this is the rationale behind the creation of the forfeiture doctrine as it existed in pre-AIA U.S. law. So back to our timeline here, you can see that under pre-AIA law, the answer to the question of is the patent valid is no. It is not valid because the forfeiture doctrine applies and the applicant was barred from filing the patent application because it was more than 1 year after they made their first offer for sale in the U.S. I did not specify that here, but that's critical. Under U.S. law, it would have had to have been an offer for sale in the U.S. So, under the old law, patent applicants inventors were faced with a choice. You could proceed and commercialize your invention as a trade secret, or you could file a patent application and then commercialize it under the patent. Once 1 year passed from that first offer for sale, you could not go back on that decision. You were bound by that choice. Then the AIA was enacted in 2011. And here's the language, and again, this part of the statute applies to applications that can claim priority to a date on or after March 16th, 2013. And I've highlighted in red the major changes to the statute. A person shall be entitled to a patent unless the claimed invention was patented, described in a printed publication or in public use or on sale or otherwise available to the public before the effective filing date of the claimed invention. So as you can see, Congress made a point here to clarify that the focus of this analysis should be on the claimed invention. They also added the language or otherwise available to the public, which has led to great debate about what exactly does that mean. Is that a separate category of prior art, or is that modifying all the other categories that are listed here such that all of them must put the claimed invention and make it available to the public in order to constitute, for example, a public use or on sale? Now, I also wanted to point out, again, there is no geographic limitation here on the offer for sale. You recall earlier we said that the offer for sale had to be in the U.S. That's not the case here. And so this is something that is new, and for companies that are operating out of Europe or anywhere outside of the U.S., they need to be aware that an offer for sale anywhere in the world can constitute a barring event for filing a patent application in the U.S. Now, the legislative history includes several different statements from different senators and representatives that seems to support that by adding or otherwise available to the public, Congress actually intended to get rid of this forfeiture doctrine and harmonize U.S. law with other jurisdictions like Europe and elsewhere that don't have that sort of doctrine. The USPTO issued guidelines shortly after the AIA was enacted in which they adopted that view. They said the phrase on sale in the AIA is treated as having the same meaning as on sale pre-AIA, except that the sale must make the invention available to the public. So more than 1 million patent applications have been prosecuted and granted in the U.S. under these guidelines from the USPTO that an offer for sale, in order to be a barring event, must make the claimed invention available to the public. So, back to our timeline. You can see here that according to the USPTO, the patent is valid, that it doesn't matter that they made an offer for sale more than a year before the application filing date, because, and so long as the process itself remains, or the invention itself remains secret all the way to that period of filing the patent application. This takes us to the Helsing v. Teva case, where it's all finally coming to a head, and we're hopefully going to have some more clarification from the courts. And the invention here in this case was a drug for treating cancer patients who suffered from chemotherapy-induced nausea and vomiting. Now, Helsing is a very small pharmaceutical, family-run small pharmaceutical company that acquired rights to this drug. But as I was discussing before, they were unable to manufacture and distribute this drug on their own, so they needed assistance. And they reached out to IFarm and entered a licensing agreement with them for the manufacture and sale of their drug. This agreement was entered into under a non-disclosure agreement, so they, in order to protect them, they understood that they'd be protected because it was all under an NDA. Unfortunately, as a public company, MGI had to disclose the license agreement to the US SEC, and it wound up becoming publicly available information. Now, honoring their non-disclosure agreement, they redacted certain portions of the license agreement, including the concentration of the drug at issue here. And that's critical because the claimed invention later on that Helsing filed a patent application for included claims that recited exactly that redacted information. Okay, so recall the statute under the AIA focuses on the claimed invention. If the claimed invention includes that pharmaceutical concentration and that was not included in the publicly available information, the argument goes, according to Helsing, the claimed invention was not publicly available, and therefore this is not a 102 event that would bar patentability. Meanwhile, Teva filed an ANDA to market a generic version, causing Helsing to file suit. And as its defense, Teva, of course, argued that the patent was invalid based on this earlier offer for sale. So, Helsing then argued, just like I'd mentioned, that that Congress changed the meaning of the statute by adding or otherwise available to the public language. They added that to the statute, arguing that that modifies all those categories of prior art, thereby indicating that in order to be prior art, like the rest of the world, the event must put the claimed invention into the public domain. Now, in May of last year, the Court of Appeals for the Federal Circuit held that Helsing's patent was invalid based on the offer for sale, since the fact of the sale was publicly known, even though the specific dosage information was not available. And the court went on to suggest in that case that the pre-AIA on-sale bar was largely unchanged by the AIA. In essence, they were insisting that if Congress really intended to overturn decades and decades and decades of precedence on the on-sale bar, they should have been absolutely blunt and clear, and they didn't feel that the statements by the senators and representatives were adequately clear to overturn that tremendous body of case law. And they did indicate that the holding was limited to those specific facts, but nevertheless, they did make some sweeping statements about how pre-on-sale bar still applies post-on-sale. And so, as a result, Helsing filed a petition to have it reheard en banc, which was then denied in January, and they proceeded to file an appeal to the U.S. Supreme Court in February, and then Teva filed a brief in opposition just last month in May. So, at this point, we don't know if the Supreme Court's going to pick up this case. There have been many amicus briefs. 10 or so amicus briefs were filed in support of Helsing's position. None were filed in support of Teva's position. So the general consensus in America is that, at least from these industry organizations, is that the U.S. patent community would be better served by harmonizing our system with the international standards. And so we'll have to see how that plays out. But at this point, we don't know whether they're going to pick it up. And I think we'll have to wait probably until the session begins October this year through, I think, June of next year. So we have probably a year or so before we know for certain how this is going to be resolved. But in view of the numerous amicus briefs, I am hoping that the Supreme Court will pick this case up. We'll have to just wait and see. Definitely something to keep an eye on. So back to our timeline here. Here you can see that according to the Federal Circuit, the answer is no, the patent is invalid if the sale was public. So on the one hand, Judge O'Malley in this decision indicated that that pre-AIA law didn't change the on-sale bar. or post-AIA law didn't change the on-sale bar. But then on the other hand, the opinion seems to indicate that it has to make the fact of the sale available to the public, which, in my understanding, is a change in the law to some extent. So it's still a little unclear exactly what on-sale bar means today. Here's the question that they submitted to the Supreme Court. Whether, under the Leahy-Smith America Invents Act, an inventor's sale of an invention to a third party that is obligated to keep the invention confidential qualifies as prior art for purposes of determining the patentability of the invention. We covered this already. So Helsing, just a quick summary of some of the arguments that Helsing made in its petition to the Supreme Court. They argued that the focus of the amended language in the statute should be the claimed invention. And when you read the statute and understanding that available to the public or otherwise available to the public modifies that subject matter, it indicates that the claimed invention has to be made available to the public. And that wasn't the case here because that dosage formula of the formulation was not in the public domain and was specifically redacted from the publicly available information. They also argued it contradicts the legislative history, with statements from numerous senators who said that the forfeiture doctrine is now dead. Bottom line is that there is tremendous uncertainty with the millions of patents that have granted since the USPTO issued its guidelines on this issue. And so all of these applicants, I'm sure many of them have potential on-sale bar issues. And so it remains to be seen whether those patents are valid or not. They also ignored the primary purpose of the AIA, which was global harmonization. It didn't just change the U.S. from a first to invent to a first to file country. It made numerous other changes as well, including, according to Helsing, that it eliminated the forfeiture doctrine. Here you can see the list of the organizations that did file briefs, amicus briefs, to the Supreme Court in support of accepting certiorari. Includes large pharmaceutical organizations. You can see Bio's on here. Even Congressman Lamar Smith, he's the Smith and Leahy-Smith American Invents Act, filed a brief saying that, yes, that was in fact what we meant. And none supported Teva. I will mention there was one amicus brief in the early stages at the federal circuit by, I think it was 30 or 40 law school examiners who actually filed a brief supporting Teva's position. That's the only one that I'm aware of that supported Teva's position to date. Now, Teva does have some arguments here, and I don't think they've been publicized and shared widely because I think nobody wants them to win on this. I think everybody wants global harmonization. But they do have some decent arguments. One of them is that the statutory bar did not apply just due to the existence of the sale in this case. Now, let's keep in mind, the entire license agreement was made publicly available with the exception of the redacted portions. So 90% of what they were claiming and the fact of the sale was disclosed in a significant way. And so much of that information was there. So it's not exactly like the situation where you have an offer for sale under an NDA and it never sees the light of day. So there was a lot of information about the sale that was made public by both parties in this case. They also argued that the statutory language actually supports secret keeping, secret prior art. Congress chose to use the term on sale in exactly the same way as it existed in the prior statute. They could have said publicly on sale if they wanted to, make it abundantly clear that that's what they meant, but they didn't. They just said on sale. Also, there are other sections of the statute. The next subsection of the statute in question here refers to disclosures and also separately to public disclosures. Well, to refer to disclosures and public disclosures in the next subsection makes no sense if you can have only public disclosures that qualify as prior art. So they do have some decent arguments here. And one that I find particularly interesting is it's not technically legislative history because it's not commentary by the senators and the representatives involved in the proceeding. But the procedural history of the AIA, they argue, also supports retaining secret prior art and secret offers for sale as invalidating acts. And what they argued was the AIA wasn't just a one-off act that wound up being passed by Congress. There were numerous revisions over the years, dating back 10 plus years. And some of the earlier revisions had deleted on sale bar. In fact, all of them had deleted on sale bar from the statutory language, instead relying on publicly available to basically cover that. And they said, but in the end of the day, they couldn't get that through. They only got it through when the term on sale made its way back into the statute, thereby indicating that it is not, and it is in fact the same on sale bar that existed pre-AIA. Okay, so what now? What do we do with this conundrum about the on-sale bar, and what exactly does it mean? Well, the cautious approach right now is to assume that the old on-sale bar is going to apply, and that an NDA is not going to adequately protect you in your discussions with third parties. So keep this in mind. It's really important. If you're a small, medium-sized pharmaceutical company, you have no choice but to work with a third party. It's okay to work with them. Just make sure you file your patent application, ideally before you have the discussions, but certainly no later than 1 year from when you began your discussions, just to make sure that you're fully protected. You might want to consider hedging your bets. You could file a provisional application now if this is an issue that's relevant for you, and wait and see how it's resolved over the course of the next year. You could always let that provisional application lapse and do nothing with it. But if the law it changes in any way, it just preserves your right and options in terms of filing an application and making sure that you're fully protected. But the bottom line is make sure that you monitor Helsing, see what goes on with this decision as it goes forward, and hopefully they pick it up. Hopefully they clarify this issue in the law. If they don't, we're going to need them to eventually, because this is an issue that's just going to keep coming up over and over again. And as the AIA is a relatively new statute, we need more case law to help clarify the metes and bounds of exactly what it entails. So with that, that's all I have, unless there are any questions.
If under the new law, if something's secret prior art, and let's say you established that certain subject matter is secret prior art, can that be used? Can that secret prior art also be used in an obviousness context?
So that's an interesting question. That has not been addressed by the courts yet, but I think that does raise an interesting question about what if they caption the opinion in the Helsing decision slightly differently. They held it was a complete bar based on the offer for sale. What if instead they said, we're just going to take this as a printed publication, and it discloses 90% of the invention, and it would have been obvious to come up with this concentration of this formulation based on the secondary reference or based on the knowledge of somebody skilled in the art. I think that would have been a much more easier fact pattern and argument to digest, frankly, than the way that they reached this decision. So I think that is something that they can certainly make an argument based on. But right to date, I'm not aware of any cases that support that at this point. But it's a good question. Anyone else?
I have another one, Justin.
Yeah.
Is it just really that you need to sell the product, but also have the NDA not in place or in place? Or was it just discussing with somebody that would be bad enough?
So under U.S. law, in order to have an offer for sale, there are two steps to the analysis. The first is that you have, under the UCC, an actual offer for sale. And the other, meaning an offer acceptance consideration, right? Or just an offer. You don't need the acceptance in order to trigger the bar. The other is that the invention has to be ready for patenting. So if you're still at very preliminary stages and you haven't fully worked out your invention, you at least have an argument that that's not an offer for sale because it wasn't ready for patenting under U.S. law. But those are the considerations that you typically need to undertake. Whether the NDA itself is going to provide you any additional value, yeah, I think it probably does. I would do it. I would absolutely have an NDA in place. As I mentioned, the Helsing case does seem to suggest that the fact that the sale was made public was part of their calculus in reaching their conclusion. Why, I don't know, because according to other statements in the opinion, the on-sale bar from the pre-AIA law still applied, which it wouldn't have made a difference at all whether it was public or private under the old law. So I don't really understand and can't reconcile that aspect of the opinion. But yes, in abundance of caution, I would definitely recommend NDAs whenever possible if you have not filed a patent application at that point.
So just that fact pattern, let's say you're an inventor and you discuss with a company that they could commercialize your invention and you have an NDA with them. Is that good enough? Because there is no sale whatsoever.
Have you filed your patent application?
No, you haven't.
I think that would, my suspicion is that would be okay if you're not offering the product for sale.
Okay.
I would definitely want to look at the specific case law on that, but you're not offering the product, you're offering the rights in that product, although arguably that's exactly what happened in Helsing. They were contracting with Helsing to manufacture and sell the product for them.
Okay.
So I'd be hesitant to do that. And if you were going to take an action like that, I would suggest that you file an application within 1 year of having those discussions, just in an abundance of caution. But it's definitely on a fine line, a gray zone there, I agree.
Okay.
Yeah.
So I think it's really great that you spoke about that today, because from a European perspective, that really scares me.
Yeah.
Because I always thought like an NDA, I thought when you started speaking about there needs to be a sale, yeah, I understand. If you put the product on the market and you just say, but it's still confidential because the process is confidential, I get it. But when you're saying just already discussing with a manufacturing partner, or just discussing with anybody about it, that they could say you put an offer out there, and even you had an NDA, it's not enough.
Yeah, and it's really, it's a huge change from a European perspective, because in the old law, Europeans didn't have to worry about it. You know, if they're offering, say, for sale in Europe or anywhere else, it doesn't matter. That didn't implicate the old statute, but now they changed the law. It does implicate the new statute, and so just be aware of that, and don't feel that a false sense of security just because you have an NDA in place. Okay. Thank you.
So, good morning. My name is Bastian Joly. I'm the founder of the patent review site GoodIP. Before I founded this company, I was an in-house counsel at the lighting company Osram, better known in the US as Sylvania. And during my time in the in-house department, I recognized two things. Companies want to learn more and more about the potential of their patents, but they struggle to do that. And on the other hand, from time to time, they also try to monetize them by selling them or by licensing them. But it's a really tough thing to do. But why will this become much more important in the next years? Why will it be much more important to know about the value of your patents? And that's where I like to look at this graph from the WIPO statistics database. You can run it yourself, you can put in any country you want. That's a statistic, patent filings by country of origin. And you see what happened to the green bar. So that's China. You see what happened in the last 10 years. So they're going from a few thousands to 1.2 million patent filings a year worldwide. That doesn't mean applications just in China, but anywhere in the world. US has also increased. If we had left out China on this bar, you would see that the Americans are doing quite well, that they're going from 400 to 600,000, while the Europeans, for example the Germans, stay very much flat at 200,000, 300,000 filings a year. But you can see China is now at 1.2 million and they're increasing every year. When you consider that the total number of issued patents is 21 million, you can see when China will own more patents than the rest of the world altogether. I would say the only way you can play this game in the future is by knowing what you have in your portfolio, by knowing where the potential is, because you can't play this numbers game. It's running out of bounds here. And the second point why you might want to think about the potential of your patent is this. Only 2% of all patents are monetized. During my time in the company, we always thought, like, when we looked at portfolios of other companies, it's at least 5 to 10% what could be quality. That's this rule of thumb everybody speaks about. Maybe 5% is good, maybe 10% is good. But only 2% are being monetized. And now you have to ask yourself, does your company monetize at least your 2%? If not, you're leaving money on the table. And could you even go further than 2%? Could you go to 5 or 10%? That's also something you may want to ask your clients, because other people go for those 2%. Question is now, how do you sell patents? And I thought about this question. I thought about art, about paintings. Because sometimes it's helpful to think in another industry or in another field and then see what it can mean for our field. So let's think about paintings. How do you sell a painting? How do you learn about the value of a painting? Not like that. Nobody would purchase a painting in here. But think about how we try to sell patents, or how we look at patents. There's like the databases, and there are hundreds and thousands of patents you look at, and you don't even know where to start. You go to the supermarket. But is that really the way you sell art? And art is intellectual property. The way patents is property. Art is creative stuff, but it's also just a vision somebody had. And the same for patents. That's a technical vision somebody had. And I think art you sell like that. You're in a gallery, you create a buzz about something, and then people talk about it. Maybe the people that come to the gallery talk about it. Then maybe a reporter speaks about it. They put something in the newspaper, and suddenly people start speaking about this new piece of art, and it gets more and more valuable. And then, having been to a gallery, what really makes a lot of sense, if there's this really little red dot at a painting, and maybe there are like 20 paintings and 15 have a red dot, it won't take long until the other 5 are sold, because that's how we humans are. If there's a run for something, we want to buy. The question is, how do you sell patents? How do you learn more about the value of patents? And what we recognized is that still many companies are like this.
Who is that?
That's a question for later on. You can ask it in there. You're hiding your patents, even so they're in the public domain. You're saying, let's don't speak about them. I don't really want a comment, maybe because I'm afraid of litigation in the US, that somebody could have made a comment about it. Or maybe you just think about, nah, I did my filing and now it's in my portfolio and that's good, let's leave it there. Just growing my portfolio. But that's where I want to go back to my very first slide. Quantity won't be enough in the future because, let's say, other people are filing much more than we are filing. That's how we think then you can sell patents and get to the value of it. That's our team, programmer and our creative guy and me. It's really start talking about patents. And that's what we want to do. We want to be a place where creative people, creative minds, visionaries, bright minds come together and find and talk about great innovations. So how could that look like? So what we do is that somebody lists their patent on our website. Then you get input from the crowd. And you can say, I want to have public input. Or I want just get connected to experts and they can help me out learning more about the potential of my patent. And then you can decide whether or not to monetize it. Quick, easy steps. What we do in the last step, and that's the reason we called it Good IP, is that we donate a part of the profits when a sale happens. Because we think that's a way how the patent owner should give back to the people that helped him. That's how it looks like. You can also go to the website, it's Good IP, and have a look at it. But I think it's the first time that somebody put a light bulb rating on patents. And here you can see a patent from Osram, and they put it out there and they said, I want reviews, I want ratings, and it got 3.5 bulbs. It's a bit like a hotel or restaurant review, but with a lot more impact, because there could be hidden nuggets that nobody saw so far. And it can be also that you get feedback where you didn't have feedback so far. You could go back and say to your patent prosecutors, look, I think we need to change something because we're getting this feedback all the time. Also, when you think about abandoning a patent, it could be a second view that you're getting, second opinion. Same, you're running a startup and you want to get investments. Everybody's just always asking your freedom to operate. They're saying to you as a startup, do you have freedom to operate? Are there other patents out there that could really hinder you from monetizing what you're doing? But it's kind of strange because usually what do you ask a startup? You say, are those great people? Would I invest in them? Do they have a product that looks cool? Do they have a vision? And is there a market for what they're doing? So you're just looking at potential. And then we lawyers came in and said, but when you look at their patents, you have to see if somebody can stop them. But it's kind of strange because you're always just looking at potential with a startup. Why shouldn't you look with a startup with their patents also at potential? What can they do with the patents? Because that's what makes a patent valuable, whether it has potential. And also you can connect to the community. That's my profile. If you like, you can also sign up and become an expert. We really saw that there are 3 kinds of experts. Number 1 is technical experts. That could be a patent prosecutor too, who knows about how the patent should be written, what technical stuff should be in there. But then we saw that you have to connect with the technical expert, a business opportunity analyst. Somebody who looks at the patent after maybe the technical person has explained it to him or to her and says, look, I understand what you're doing here. This could be relevant for this and this market. And that market has this potential. And thirdly, we think you need a licensing executive. Somebody who says, I'm prepared to pick up the phone and speak with a company and tell them this is a patent that could be interesting for them. And do the sale for them, the way you do it for art. With art, you also bring different experts and different people together. And then you can make a deal happen. And that's what we think, bringing people together, patent owners with experts, and then you get valuation for your patent, and you may be able to sell it. It's wisdom of the crowd or crowdsourcing. And because I want to speak about patents and social networking, a bit like history, what happened so far in that field, what was tried. First one was really initiative by the USPTO called peer-to-patent. Has anybody heard about it? Ah, cool. 3. So what they did is really they went out and said, send me prior art for those applications. If somebody wants to hand something in, we will consider it. And they got lots of input, thousands of reviewers and input. And I think of the stuff they got, they used 25 in real prosecutions. But then at some point, I think they kind of lost interest in. Not so much, I think, the USPTO, but really just running it. Maybe because it was negative. We people like to be negative. We say this patent should be killed. But what we want to do at Good IP is look at the potential. Find the stuff that can change the world and not kill the stuff. That's the reason I think you wisely said I'm one of the good guys, because we want to find potential. Not hurt somebody with the stick and also not kill patents. Second one on the right side is ask a patent. That's really where you can put any question in there that you have about patents. It's really helpful for inventors. And I think maybe Justin, they want to put in a question then, what about NDAs? Will it be still sufficient or not? I don't know, yeah. I think so far they will just put in, just do an NDA and you're safe, but I guess in the US that won't work any longer. It's a bit tricky, putting in questions there. It's not legal advice that you may be getting, but at least it helps you. And I think that's also how we make patents and everything more approachable by people. By saying it's not just legal, it's something you really should talk about. There's no harm in it. When you think about it, that's the reason we have a patent system. You said it, put it in a public domain so that other people can think about it and build on it. And then for some reason, like 50 or 60 years ago, we said, let's don't speak about patents. I heard about some companies, they even prohibit their engineers from looking at patents. They said, don't look at it, it could hurt us in litigation. Don't build on that. Why do you then grant a patent in the first place if people are not supposed to look at it any longer and not speak about it? Oh, I don't know what happened there. Third one, and that's really a very interesting one, are the Stanford IFarm teams. So what Stanford said is that really let's use the expertise that we have at the university. Take students, law students, tech students, and maybe business students, put them together with external experts, alumni, and show them some of the innovations that we have at Stanford. And give them a semester to come up with ideas how to commercialize them. And when I recall correctly, or it's 25% of all innovations at Stanford that are being licensed. Not just because of the IFarm teams, but just compare 25% to the standard 2% overall. So Stanford is doing a good job, and they thought, let's bring people together. We are doing the same on our platform, but also in workshops. But we just bring people together and say, let's speak about this patent. And quite interestingly, it works. You bring people together on a Saturday morning and you say, here's an innovation, what do you think about? And for 4 hours, they just speak about the potential, and only for 1 minute they speak about why was this patented in the first place. That's really what strikes me as odd, because we as patent professionals always think that people always just think about, that was done before, this can't be inventive. But if you really address it in the right way, people think about how can it change the world, because that's what we humans want to do. We want to change the world. Lastly, don't want to forget this one. There are really already first crowdsourcing platforms where you could put out a study and say, can you help me? But it seems they really have success with prior art studies, again, killing patents. So they would say, please help me find prior art against this patent. That's not what we really want to do. We want to find potential and find stuff that can really make a difference. Why does it work? What I like to tell is the story about the US Submarine Scorpion. It was like in the 60s that it disappeared. And nobody knew where it was. The original search area was 100 miles wide and hundreds of feet deep, thousands of feet deep. And nobody knew where it was. And they had two ways how to look for the submarine. One was just go out and look for it. And the other one was like that a Navy officer called John Craven said, let's put together a team of different people. Experts, salvage men, submarine captains, mathematicians, and really let them look into where the ship could be without really sending them out there to the ocean, to the Atlantic Ocean, but really think about it. And they put together different opinions where the boat could be or what could have happened. And John Craven just aggregated what they did. And they found the ship just a few feet away from where they had aggregated that it would be found. And that's where I think that the wisdom of the crowd comes in. When you have diverse people and independent people and aggregate that, you can achieve much more than what you can just achieve with one expert or two experts. You don't need hundreds or thousands of experts. You just need a few. But aggregate them, that's a lot better than just relying on, let's say, maybe your head of R&D in the company. Because he may have an interest why he promotes a certain patent and why he wants to have another patent abandoned. Or just really, if it's not the head of R&D, there may be people that don't want to go for, let's say, this patent because it was not invented by the head of R&D. It was invented by some kind of maverick in your department. And that's really where an outside opinion can help you a lot. Hope you enjoy what I talked about. Hope you find us interesting. Happy to field your questions. Thanks so much.
Is there any questions?
Who are the reviewers that you all get, and how do you get them, and why are they interested in going to your website or whatever and reviewing patents?
Yeah, so number one is just really they want to make a difference. That's because of the donation. Also, they want to find interesting stuff. Number two, they want to be visible. They want to make a name of themselves. And number three, there's also a reward system in place. So they can also make money.
I've got mine. Do you feel like there's ever like competing interests where like maybe one company who obviously has a lot of pride in what they're doing has maybe a vendetta against their competitors, and they see other IP and in fact wants to disparage their IP, and does that ever play into what you're seeing?
So we haven't seen that so far. It was just really that people look at potential. I think it can happen in the future. I think to some extent at peer-to-patent, that was supported by IBM. And they gave credits to their employees to work on that system. And I think in a way you could say that was already influencing the patent system in some way. I would say if somebody has a vendetta and writes something about a patent, it's just a way you have vendetta about art. If you write it's bad art, it will just put the focus on it.
Yeah.
So you may want to do that. So I heard that, yeah, maybe people will put something out there just to criticize. Interestingly, I heard from another company, they said, yeah, if my competitor puts up something, then I will review it, and I will review it in a very good way. And I was like, that's the first time I'm hearing this. Why would you do that? And he said, so that the guy will have a lot of work looking at his patents again, even though they're rubbish. So, I mean, yeah, there will be different motives, but in a way, those different motives will make it powerful.
Well, and I also wonder, in the US we have willful infringement, right? And if you go on record saying that this one patent is fantastic, wow, what a great idea, and then later on there's a lawsuit, that's going to be on a poster at trial as evidence to support willful infringement. So I wonder if there's a hesitancy with large companies against making commentary for just that reason.
Yeah, so I mean, the point is those are independent experts, and they can be registered, and then we kind of would know who it is, but they can also just post. So I wouldn't expect that really large companies will in the first place really tell their employees to go out there and do reviews under their real names and everything. That can change at some point when this gets more recognized. And I think it would be a good thing that people are less concerned about willful infringement and more concerned about, do I really have value?
Right.
Now, I've never used Ocean Tomo, but can you comment on how, if someone was to use your model as perhaps a patent clearinghouse, sort of getting that licensing person to pick up the phone and say, please, can I represent you and move this forward? How does that compare to like the Ocean Tomo model where people put their patents in, for an auction, which is similar, but I don't think quite the same as you analyzed or analogized to
Yes.
Selling art?
Yeah. So I mean, auction or brokers, that's a marketplace in a way. You say, I put that out for sale, and then people can go for it and they can bid for it. And I think that works very good in the art market for certain pieces of art where you really build up the price. We don't see ourselves really as an auction house. What we say is we want to create discussions about something and find the value in the first place. So that could be an difference that you really see in a marketplace. I mean, there's people that do a very good job in vetting stuff. And Ocean Tomo could be one of them, that they're saying I really just put out stuff for auction that I vetted myself and where I think this is good. But I think there are other people out there that are just putting stuff on the market and saying, yeah, look, I mean, the buyers need to look if there's anything interesting there. And so I think what we're really in is in the review business, in connecting you as a patent owner to people that can help you. And you have the choice between saying, I want public reviews because I'm not afraid. I cherish the relevance. That's really what our creative guy always said to me. He said, if you want to be relevant today, you have to be public. And that's what we all know. Facebook, Twitter, to be relevant, you have to go out there. And you have to, going back to the picture, Donald Trump, you have to be prepared that people speak with you and criticize you for what you're doing. And whether we like it or not, I mean, he has a lot of attention. And it's the same here. And that's what I think is also in this review business where you can get public reviews or also just say, here's my patent. I don't really have any clue about it, whether it has potential. And I don't want to put any further money in there. But if you approach me with a cool deal about it, and maybe the deal is just I will look at it for this and this amount of money and give you input on it, then I think it helps you. And only the transfer or the sale or the license can happen at the end. And that's what we really thought, coming back to your question. We thought selling a patent on the internet is really difficult. It's a bit like selling a plane on the internet. But we said getting reviews, getting input about something, that's what you can see is possible. See Wikipedia, see Quora. You can really get views of people. And that's what we thought is possible on the internet. And that's where we're starting off. Thanks a lot. I don't know how we go from here because I think we kind of lost one speaker.
Is there any more questions? Well, in that case, could you please answer who was that person, in your presentation, hiding the patents?
I think our graphic. Any ideas who it could be?
I think it's Donald Trump.
I think so. I think our graphic designer did a very great job. I mean, I always have to say, your speech should be more interesting than your slides, and that's what I told him, but he's always doing such a cool job with that stuff, so I need to stick with him. And I mean, when he put that out, I said, does it really need to be Trump, and does it really need to say Panama Papers? But that's what he wanted to do. Thanks a lot.
Well, if I have to draw some kind of conclusions, the two speeches were not about the same items, let's say, but there was something that put them into relation, which was the secrecy against the publicity of information. So actually, it's not something that goes, it's so different one from the other, because what was told by Justin is that we must keep into consideration, we as a European also lawyers, this fact of possible damage or possible harm coming from discussions to make value from an invention. Well, in the discussion made by Bastian, this doesn't occur. It's true, we experienced that, when I first, let's say, started studying patenting, I always was worried about talking about the contents of the patents with people the very first time, because I didn't understand that it was there to be discussed. And it's still like this, because maybe there is this, let's say, fear for incremental inventions or too much attention on your creative ideas and so on and so forth. But the initiative looks great to me. And the two things are not, let's say, clashing one with each other. So.
Yeah, I mean, definitely you should go for a patent first. Definitely
so in the end, it's go for a patent first.
yeah, I mean, that's for sure. I mean, at least go for an NDA. Mm-hmm. But I mean, really, I learned today that it's not sufficient any longer.
Maybe not.
So if there's no any other question.
I guess they don't have any question, but maybe if any question arises, you're most welcome to ask in the, networking lunchtime.